So this video is going to take us through how you go about stating, explaining, applying the law of self-defense to a scenario question. So starting with the question, as you always do, we will be advising Ian of his potential criminal liability for the incident against Richard. Now, of course, if this was a real exam question, you would first of all have to establish the offence before you establish the defence. So the scenario, Richard and Ian are chess players. Ian is convinced that Richard has cheated. That evening, Richard meets Ian in a bar. When Richard arrives, he finds that Ian has already drunk several glasses of whiskey. Richard approaches Ian with an outstretched hand in order to offer his commiserations. Ian, believing Richard is about to lashes out at him. The glass that he's holding causes a deep gash in Richard's face. So we're advising Ian of his potential criminal liability against Richard. So we start with a general introduction to the law of self-defense. And we need to mention both the common law and the statutory provisions. So under the common law, a person may use reasonable force either to defend himself or another from attack or to protect property. Additionally, under Section 3 of the Criminal Law Act 1967, a person may use reasonable force to prevent crime or assist in the arrest of an offender. So that is the public defence. So we're going to state, first of all, that to succeed, the defendant must first prove that he actually believed in the need to use force. And this is a subjective test, so it doesn't matter if that belief is mistaken. So in Gladstone-Williams, Lord Lane said that the defendant must be judged against the mistaken facts as he believes them to be. However, this doesn't apply if the mistake is caused by alcohol. And if we apply this, we can say, well, it appears that Ian's belief in the need to use force is mistaken because he's intoxicated, meaning straight away he's not allowed to use the defence. So even though our defendant has failed really at the first hurdle, it's not our choice as his lawyer as to whether or not he gets the defence. So we do have to continue through the rest of the defence. So secondly, the level of force that the defendants use must be reasonable in the circumstances as he understood it. And we explain this with the Court of Appeal decision in Owino, that this is an objective test and this is not necessarily minimal force. But if we look at the case of Martin, killing an escaping intruder with a shotgun was considered to be unreasonable force. And recent Crown prosecution guidelines state that reasonable force is less than grossly disproportionate. And we can apply this by saying lashing out with his hand may have been reasonable in the circumstances. And then we have the final section, which we will state and explain all of the law, and then we'll apply it at the end. So it's possible for the defendant to make a preemptive strike, as in Beckford, where he feared for his life, so he shot the victim dead. Also, there's no need to retreat prior to the use of force, as seen in the case of Bird, where self-defense can also be used even if the defendant was the initial aggressor. And in Rashford, the victim and the friends responded out of proportion to the defendant's initial aggression. That was allowed as well. So we can apply by saying, in our case, it would appear that Ian made a preemptive strike, which under usual circumstances is allowed. However, in the conclusion, we can say Ian made a mistake around his need to use force because he was intoxicated, and therefore he's not able to use the defence of self-defence.